Hello, and welcome everybody to the third of 6 masterclasses that are taking place through October. These are facilitated by Willis Towers Watson's Climate and Resilience Hub and supported by Forum for the Future. And these are also funded through the generous support of the Loudest Foundation. I'm Charlene Collison of Forum for the Future, and I am your host for today. Just a couple of technicalities. You will notice that on joining this class, this masterclass, all the participants have been muted, but we do encourage you to add any questions you'd like to pose throughout the session in the Q&A session, which will follow. So you can activate the Q&A panel by clicking the 3 dots in the bottom right-hand corner of your window and select Q&A. So please keep those questions coming and we'll answer as many as we can. We also want to highlight that this session is being recorded, and also we encourage you, if you possibly can, to watch it through a desktop device rather than, for example, a smartphone. You might have some issues if you try to join on a mobile device. So technicalities over, let's dive in. With a brief bit of context setting, we I think all know that the entire cotton value chain, from producers, processors to brands, retailers or traders, it's all facing increasing exposure to climate risk. And at the same time, the sector itself also contributes to climate change. So for cotton to be resilient and viable in future, to thrive in a world that is increasingly disrupted by climate change, the cotton sector and the whole textile industry has to change radically, and that's going to need change on a system and a sector-wide level. So thanks to the Loudest Foundation, over the past 5 years, Cotton 2040 has been working on its mission to encourage dialogue, cross-sector collaboration, around the issues that are critical for cotton's future to help facilitate the shift to a global sustainable cotton industry. And through October, we're holding a series of 6 masterclasses. These are covering a range of cutting-edge topics, and they're tailored for the cotton industry to help build a better understanding amongst brands and retailers and others, to help them to embed adaptation into their strategy and targets. And today we are focusing on climate risk. So I'm very, very pleased to introduce our speakers on our panel today. We're going to be hearing from Nadine Kudel, who's the director of the Climate Liability Team at Willis Towers Watson in the Climate and Resilience Hub. Welcome, Nadine. We have John Firth, who's the co-founder and the CEO of Acclimatize. Acclimatize, by the way, was acquired by Willis Towers Watson in November 2020, and John has been working for nearly 30 years in the area of climate adaptation. So we're very fortunate to have his experience with us today. And we're also joined by Divya Varma, who supports the climate liability work in her new role at Willis Towers Watson. So without any further ado, I'm going to hand over to Nadine to kick us off and wish you all a good masterclass. Thank you.
Thank you so much, Charlene, and hello, everyone. I'm delighted to take us through some key climate liability related issues and reflections, and John, Divya, and I are also happy to take any questions after the presentation. So let's get started. Let me share a story with you. So earlier this year, a group of young climate activists sued the German government over its Federal Climate Protection Act. The Climate Protection Act is intended to ensure that international, European, and national targets for protection against the effects of climate change are met, and in particular those of the Paris Agreement. So this activist group argued that the German climate law was unconstitutional and in conflict with their rights as young people and citizens. And I'm delighted to show you today a short clip from an interview with one of the young activists, Linus Steinmetz, who spent a couple of years protesting before he turned to the court. So let's play the video. Lidis, can you tell me what was your reaction when you then found out that the court found in your favor? Can you describe your feelings, your thoughts?
Actually, I was incredibly surprised that the court actually gave us the rights that we always imagined that we had, but we weren't expecting such a clear verdict on our lawsuit. So I had just prepared a kind of statement in advance to my expectation that we would not win the suit. But then surprisingly, a good friend called me and told me that we had surprisingly won on almost all of the counts that we sued them on. So that was a very happy and big success.
What motivated you to take legal action in the first place?
So essentially, I started off as a normal climate activist, as a young pupil out on the street who was just protesting in order to get the government to implement more ambitious climate legislation. But after a while, we realized that even while doing that, the government that we had pursued and that we had even been in very serious talks with was only doing the bare minimum of what they think that they should do. And we realized that they weren't as serious as we wanted them to be. And as a kind of last resort, as a last measure, we decided after a insufficient law had been passed that we needed to sue, that we needed to use the democratic rule of lawsuits.
So what can we take away from this? What can we learn from this? My first point is that strategic litigation cases are on the rise. And when I say strategic litigation, then I mean cases where the claimant's motives go beyond the concerns of the individual litigant. So those are cases, they aim to change the behavior of, in this case, the government, the German government, or industry actors, and bring a broader societal shift. And the second point I want to make is, though the number of climate laws and policies is increasing, these do not represent the sole basis for climate-related action, because as we have seen, legal action can also be brought, for instance, under existing law, and in this case here it was constitutional law. So the liability exposure is likely to be broader. Next slide, please. So there are three main categories of climate risk: physical, transition, and liability risk. Liability risk can arise from failures to manage or disclose physical risks associated with climate change, such as acute climate-related events like heat waves, floods, and wildfires, and chronic impacts of climate change like sea level rise. And liability risk can also arise from the transition risks to a net zero emissions economy. So this would cover cases brought against companies, for example, on the basis of their failure to take sufficient action to reduce greenhouse gas emissions. So this can open the door for legal claims, for example, from investors who feel that companies have failed in their duties to manage transition risks. And then legal risk can arise from compliance with existing laws. So that was the case we just showed, as well as new climate-related regulation, laws, and litigation. And we will look at this in a few minutes. Next slide, please. So defining climate liability risk. That's not an easy one because there is no standalone definition. Climate-related legal risk is, as you can see here, defined differently across the board. So some organizations have a broader and some have a narrower definition. Climate liability, I would say, relates to the legal framework that outlines and determines responsibility for climate-related actions and how those responsible are to be held to account for fulfilling them or actually not fulfilling them. Next slide, please. So why is this important? Why is this important for brands and retailers? Well, there are many climate risk frameworks developed by business sector organizations, and I'm sure many of you, or even all of you, are familiar, for example, with the TCFD recommendations, the recommendations from the Task Force on Climate-Related Financial Disclosures. So these are frameworks that can be used to assess risks and opportunities. And so business sector organizations provide guidance for how to assess, disclose, integrate, and manage climate-related and environmental risks. And we've put this up here to show you how litigation risks actually run through the entire structure of the corporation. So we see that litigation risks appear in the governance structure of a firm, in its strategy, in its policies and procedures to assess, monitor, and report and manage risk, and as well in its disclosures. So it is important to consider and address all three: climate risk, physical transition, and liability risk. Next slide, please. And I think with that, I hand over to you, John.
Okay, thank you very much, Nadine. Before we go much further, I think it's quite important that we just think about what is it that's actually driving this interest in climate liability and potential litigation. And from where we sit, what we're seeing is an exponential rise that's taking place. So if we just go to the next slide, please. We've identified here 6 drivers on the right-hand side. Now I'm going to ask you to do a little bit of work here, and just quickly, I'm going to give you about 30 seconds to, I think there's a polling screen you can see, is to, out of these 6 areas, pick the top 3 that you think or you consider to be most significant for your business. So if you could do that now, please, that'd be good. Thank you. Okay, thank you very much. That will close the poll now. The poll will now calculate in the background for a few seconds. We haven't just drawn these 6 drivers out of the air. These actually come from a piece of work undertaken by the Geneva Association, which perhaps some of you won't have heard of, but they are actually the think tank for the global insurance industry. So that straight away tells you the insurance industry is concerned about this. And secondly, also from the other authors were Clyde & Co, who are a major corporate law firm based in London, who we are also partnering with on giving clients advice in this specific area. So if you look at the poll results, which I think you can now see, we'll see no answer scores highest, which is not surprising actually, because this is still a relatively new area. For many companies, it's not something I've actually experienced yet, but we are seeing some interesting scores across the range there. Perhaps what's interesting, availability of funding, and perhaps implications of COVID have not ranked particularly strongly there, as you'd expect, because again, they're not directly related to this subject at the moment in terms of your interests. But what I'll do is I'll go through some of these drivers now to give you a bit more background to them. So if you can go to the next slide, please. So here's 6 of those drivers. We dropped the COVID one from this. I think the first thing, as I mentioned earlier, about this exponential rise in interest, and that's driven in itself by the fact that impacts of a changing climate, both in terms of the physical risks, the losses and damages, and also because of the cost of transition, are beginning to be experienced. People are seeing these, they're coming through into their balance sheets. And what's also happening is that as they come through and financial loss can be accrued to them, inevitably people start to look to see if the courts are available as a recourse for action to recover some of those damages. So it's a natural progression that the courts are being brought into it. But as you heard earlier from Nadine, we're also seeing other interests in the way that litigation is being pursued. So on physical risk, we've seen obviously that people are beginning to suffer loss and damage. That is becoming more and more apparent, and will increasingly so. There is no question of that. On transition risk, whilst countries are planning to accelerate towards net zero, there is still a lot of work to be done in that space, but it's inevitable that some companies, and those companies who don't transition quickly, or don't transition in accordance with the plans of their countries will find themselves at risk from their own investors looking for redress, particularly if we're talking about stranded assets and loss in value of company shares. On increased awareness, it's not only the public awareness of climate change that is growing, it's the public recognitions that courts can be a forum for advancing climate action. And you've seen that from the clip we showed you from the situation in Germany. The courts are becoming very involved in not just looking at interpretation of new laws coming through, but reinterpretation of existing laws within the context of climate change. There are increasing international climate commitments. I think Nadine's going to talk to you a little bit more about this, but what we're seeing is a plethora of international laws and policies coming through, all of which are making this a very fast-moving space. Availability of funding, what you've probably not noticed in most situations in the corporate world, but is happening, is that trust funds and philanthropist funds are actually putting money up to support organizations, particularly in the public sector, take action. So this is an area where funding is becoming available. Evolving standards of care. Anybody acting in a professional interest owes a duty of care, either through their own professional membership of an organization or sometimes through regulation, but they owe a duty of care to their clients. And that duty of care always involves giving best available advice, taking in best available knowledge. And increasingly, we're seeing people begin to question whether they've received that duty of care when they paid for professional advice. So watch this space for professional advisors being not only the people advising, but also the people being brought to court. And finally, developments in climate attribution science. We're getting to the stage now with our climate science where we can determine the probability of an extreme event, for example, what that probability of that event occurring if there was no anthropogenic climate change and if there is. So we're getting an indication of this event and its probability of human influenced climate change and emissions have actually contributed to this. Now, this is creating a great deal of interest with legal scholars, with practitioners and climate scientists, because it's starting to pave a way for the courts to determine whether an event can be laid at the doors of an emitter. So I'm going to end there, I think, and pass over to Nadine to take through some more slides.
Thank you, John. Thank you very much. Let's start with the recent IPCC report, the recent report from the Intergovernmental Panel on Climate Change, when we talk about what we are already seeing and mapping climate litigation. So this report notes that outside the formal climate policy processes, climate litigation is another important arena in climate governance. So the IPCC gives credibility to climate litigation as a tool or powerful force in climate governance. And I hope you can see, if you can go to the next slide, please. Yeah. I hope you can see this box here on climate legislation. So this is partially driven by the UN process. So the volume of specific climate legislation and policies has increased 20-fold during the past 2 decades. So we have now over 2,800 new laws and policies. And as you can imagine, the introduction of climate-specific legislation is shifting the compliance, the disclosure, and the due diligence landscape. And then when we look at climate litigation, we have nearly 3,000 cases of climate litigation, and over 1,000 cases have been brought in the last 6 years. So I'm sure all of you are familiar with the cases that have been brought against the carbon majors and other fossil fuel companies, but there are cases targeting a wider variety of private sector and financial actors. So we are also seeing cases targeting the food and agriculture, fashion, transport, plastics, and finance sectors. And there is more diversity in the arguments being used. For example, incorporating themes of greenwashing, and we'll look at this in a few minutes. And then when we look at the geographical distribution, or this heat map here of climate lawsuits worldwide, we see that outside the US, the majority of cases have been brought in Australia, the UK, and in the European Union. And more than half of these cases are decided in favor of climate action. Next slide, please. So here we've listed some different types of claims, or we call it main liabilities that businesses face. And most of these fall under the category of climate change as a financial issue, such as failure to mitigate impacts of climate change, failure to adapt to the impacts of climate change, and failure to disclose climate-related risks. As I said, climate-related greenwashing litigation is gaining pace, and this is really to hold companies or states to account for various forms of climate misinformation. And we'll also look at this in a few minutes. But before so, I'd like to flag up the orange box here. And these are the cases that use existing non-climate related legal frameworks to bring climate related litigation. So this is where Linus's case would fit into. And these are the cases where judges are interpreting existing laws through a climate lens. And then I'd like to share another trend. We are also seeing more litigation focusing on personal responsibility. So these are the cases focused on the duties of directors, officers, and trustees to manage climate risks. So now let's move on to greenwashing. To the next slide, please. So greenwashing is becoming one of the hot topics in the context of climate litigation against corporates. But what is greenwashing? Greenwashing is where a company uses public messaging, advertising to appear more climate or environmental friendly than it really is. It's a technique used by certain companies to distract consumers from the fact that their business models and activities are actually causing environmental or climate damage or harm. So greenwashing is not new, but there's been a huge uptick in the interest amongst customers. And you can see here in particular, young customers who are really conscious about their purchasing decisions. So decisions around environmentally and socially conscious products. And you can see here some figures from a Client Earth survey. So companies have a real financial incentive to appear sustainable and socially conscious. And then we've presented some greenwashing narratives, one of which is green innovation. And this narrative avoids directly addressing climate change, but presenting the company as environmental conscious or engaged or committed to technological innovation or low carbon technology. And another narrative is called misdirection. So this would use messaging about sports or fashion to direct attention away from the firm's core business or responsibilities. And then the third narrative we wanted to present is on nature rinsing and executional greenwashing. So this is when companies use images of nature or female presenting people or young people, experts, sports people, celebrities, etc., to strengthen their messages of greenwashing and misdirection. Next slide, please. So let's take a look at the impacts of legal cases. And I think I should start with saying that climate liability issues are vastly underestimated by most businesses, and they can really affect a company's reputation. So we see that legal cases attract considerable media attention, and just the speculation of a company being sued can trigger reputational costs. And not only for the accused parties, but for an entire industry sector. So a company's reputation is its most valuable asset going forward. And in order to protect it, the company needs to be proactive. When we talk about costs of climate litigation or the impact of legal cases, and this is a very complex subject and would need another webinar series, but it is really difficult to measure and estimate these costs, also because records and data are not publicly available. However, I think we all agree that lawsuits are very expensive and unfavorable. Let me just make 3 quick points here. The first point is that costs arise not just at the end, not just when a company loses a case. Costs arise at all stages of litigation. The second point is besides the payouts or the fines at the end, it also includes legal and administrative costs, lawyers' fees, and insurance costs. For example, if the insurer thinks that a business is more likely to be sued, that may have an impact on its policies. And then consequences may be also much more far-reaching, with obviously the loss of business, but also difficulties in retaining and attracting talent. And the last point I like to make is beyond the costs arising from cases directed at the company, there may be costs a business may suffer indirectly when others are sued. So this could include counterparty credit risk, market risk from the assets that a business holds, and as mentioned, insurance and reputational costs for an entire sector. Now I'd like to move to the next session. What are the solutions? But before we talk about the solutions, next slide, I think we have another poll question. Yes. So I'd like to invite you to provide your answer. The liability risks of climate change are already something that my company is actively considering. Yes, we have actively identified liability risk for various climate scenarios, or no, we have yet to consider liability risks in a meaningful way, or I don't know. Okay, well, it's interesting to see that some of you have already identified climate-related legal risk, and that also some of you feel that these risks need more attention. Well, let's move to the next slide, how to manage climate liability risk. So in the last few minutes, we will focus on the response or the steps you can take to improve your resilience and preparedness for climate-related liability risks and identify opportunities. So the first key is understanding your current climate liability risks, and this by learning from existing climate change case law. So what were the arguments in court? What is it we are seeing already, etc. And by analyzing the commercial landscape and legal, jurisdictional, and constitutional aspects specific to your business. The second focus area concerns your reporting regimes and your compliance with climate-related legislation. So as mentioned, the landscape of climate regulation and disclosure is rapidly evolving, and you would need to address that and disclose adequately. And the third focus area is concerns the identification of high-risk contract hotspots, especially along your supply chain. So which contracts are exposing your business or your partners to particular climate liability or regulatory risks? And last but not least, the performance of an insurance portfolio analysis is also very important in order to then find suitable coverage solutions in the marketplace. And with that, I hand over to Divya to talk about what is next.
Thanks, Nadine. Can you go to the next slide, please? So what is next? We've just heard about climate liability. I would now like to talk what's next on the horizon, which is biodiversity liability. Can you go to the next slide, please? Now, biodiversity as a whole It includes every living thing in one region or ecosystem, including plants, animals, humans, bacteria, and now today, the world is now thinking beyond a single habitat or species, but rather in terms of broad biodiversity goals, having much far impacts on regulation, policy making, and liability risks to corporates. We've already seen the growing number of climate change litigation cases all over the world, and this has only set the wheels in motion for further biodiversity litigation. Why is why do we think that it's important? Nature loss poses both risks and opportunities for business, and more than half of the world's economic output is around $44 trillion is moderately or very highly dependent on nature. And unfortunately, currently, financial institutions and companies don't have the information they need to understand how nature impacts the organization's immediate financial performance or even financial risks in the long term that may arise from how an organization either positively or negatively impacts nature. Here we can see on the slide some facts from Client Earth. 1 million species on the planet are already threatened with extinction, and there are already 25 active cases defending wildlife and habitats. One particularly notable framework is the guidance from the Task Force on Nature-related Financial Disclosures. We already heard Nadine cover a little bit about the TCFD, or the Task Force on Climate-related Financial Disclosures. The TCFD is a framework which provides a list of recommendations to report on climate-related metrics, governance, emission targets, and most importantly, risks and opportunities. Although TCFD and TNFD themselves are not legally binding, there are many climate rules we are seeing today. The recent SEC's climate disclosure rules, for instance, they have been based on the TCFD. And it's very much possible that something similar might happen with TNFD down the line. TNFD is a market-led, science-based framework which will enable companies and financial institutions to integrate nature into decision making and to report and act on nature-related risks. It is due to be released in September 2023, and the main aim is basically to allow better information, which will help financial institutions and companies to incorporate nature-related risks and opportunities into the strategic planning, risk management, and asset allocation decisions. We've already seen disclosures as one type of a liability that corporates may face, and incorporating these frameworks, having full due diligence disclosures will avoid that kind of a liability. Next slide, please. Now, what are the drivers of biodiversity liability? The Commonwealth Climate and Law Initiative, it's an international legal think tank. They have proposed a framework of biodiversity liability related liability risks. There are 3 high-level categories and 10 subcategories of biodiversity related liability risks. These categories delineate the types of liability that may arise from or which will be driven by the diversity loss and their impacts on financial markets. So in front of you, you see the 3 broad categories. The first one, liability risk from physical or ecosystem impacts. It can arise due to direct impact through a direct failure to prevent biodiversity loss, or even an indirect failure. If you fail to manage or adapt to any biodiversity related physical risk, if you fail to comply with any regulatory requirements associated with biodiversity laws, as we already know, courts are now looking at other regulatory laws through a climate lens. Very soon, it will be looked at through a nature related lens as well. The second main driver, liability risk from the transition to a sustainable or regenerative economy. How can this arise? If there is failure to manage or adapt to biodiversity-related economic transitions, transition risks. Now, transition risk can arise from a policy, from regulation, from technology, or a shift in any stakeholder preference. or if there's any anti-biodiversity regulation claims disputing the application of any biodiversity-related regulation. The third kind of driver is the liability risk from misrepresentation of biodiversity risks. So if there is very similar to greenwashing again, so if we see a market misrepresentation of material biodiversity related risks in your regular disclosures, if there is a promotional misrepresentation or greenwashing in advertising or promotion, if there is a financier or an auditor liability for investee, or if there's a client misrepresentation under any of these activities that I've mentioned. Next slide, please. And I think here, Charlene, I can hand it back to you.
Thank you, Divya, and thank you also to Nadine and John, our previous speakers, for giving us that summary. There's a lot to think about and a lot to do, particularly as the impacts of climate increase, as we know they will. So as a reminder, you can find more information about climate risks to cotton on the Willis Towers Watson website. And I really recommend you take a look after listening to this masterclass. There are plenty of materials there, resources available to you. They're all free of charge. And that includes an interactive map of climate, of physical risks to the global cotton growing regions, as well as the climate reports that we published earlier in the year on global climate risks, and also a deep dive into India. If you would like to hear more about Cotton 2040 and its initiatives, do contact my colleague Hannah Caneen from Forum for the Future. And that might be if you want to learn more about the topics we've discussed today, or need further guidance on what your next steps as a company might be along your climate journey. For those, please contact our panelists at Willis Towers Watson. So we're shortly going to go into the Q&A. I just want to remind everyone that on behalf of Willis Towers Watson, as well as Forum for the Future, our role is really to provide advice. Willis Towers Watson provides advice on climate risk, and advising on legal risk from climate change would be the role of legal partners. So we, and particularly Willis Towers Watson today, are not here to provide legal advice, but we are very happy to speak to a range of questions. And I'm going to start with a question to Nadine. Nadine, can you explain what attribution science is and how it could influence climate litigation?
That's an interesting one. Well, John has covered what attribution science is, and attribution science is becoming sufficiently recognized and established enough to provide support in legal disputes. I think it was 2 years ago, our research partner, Columbia University, established the Climate Attribution Database. And this is something really interesting to look at, because this database helps scientists understand how attribution research might be applied to laws and policies, but it also enables lawyers to access the latest research to support their cases and their argumentation. And it can provide policymakers with the resources that offer justification to their climate policies. So it is really an interesting space to watch.
Thanks, Nadine. And John, I know you've been working in this space for a long time. Is there anything that we didn't cover today that companies really needed to be prioritizing and paying attention to?
Thank you, Charlene. I mean, this is only we've only been able to give you a snapshot in the time available today to run through a particular aspect of risk associated with liability. But when we look at how companies need to and are reacting to the issues associated with the changing climate and also transitioning towards a low carbon world, it's important to recognize that actions they're not taking elsewhere can then actually affect them in terms of their liability risks. So perhaps two examples to give you. One is we all need to take really great care and exercise good due diligence on who you use to provide advice and metrics and analytics. The reality is there are very, very few people across all the professions you might think about, whether they're scientists, management consultants, value chain, supply chain people, engineers, etc. But there are very few people who have been exploring the impacts of a changing climate and the implications transition will have, and have a detailed, in-depth knowledge gained over many years. Many organizations and individuals will tell you they have the expertise, including some very reputable, long-standing companies, but actually they're very, very new to the game. Just look at when they established their climate change expertise, and it tells you they are learning themselves. So just be wary and question in your due diligence. And with regard to analytics and data, one thing to note is we've seen quite a large number of what we call black box solutions coming to market, where you pay for the service or access to the service, and out comes a figure, out comes an indicator for you. Now, these black box solutions tend to be wrapped up in IPR, so that means you don't understand what's going on in the black box, you don't understand the assumptions being made. And if that's happening, I have to ask, how can you have confidence in the results that it's giving you and how you use it in your business if you don't understand that process? So, and of course, if you don't understand and you've been taking and using that as your information source, straight away you're creating a situation in which there could be a future litigation liability. The second area I just want to mention, it picks up on a little bit on the greenwashing angle that Nadine was talking about. It's now fairly commonplace to see companies talk about being Paris aligned, as though somehow that gives them the badge of trust us, we're okay. Now, most people, when they talk about Paris aligned, are talking about transitioning to a net zero world. What's interesting about the Paris Agreement, it never mentions transition and it never mentions net zero. Just take that in. So straight away, by saying you're being aligned to something that actually is different to what you think it is straight away exposing you. You need to understand that the Paris Agreement contains 29 articles covering a whole range of areas such as adaptation, capacity building, finance, knowledge and technology transfer, loss and damage, greenhouse gas emissions reduction. And so by saying you're aligned, you're automatically saying you're aligned to all the 29 articles. Now, this is an area we suspect and expect to be a source of litigation. It's only a matter of time, particularly for the activist type organization start targeting particular sectors. So telling the world you're Paris aligned may leave you open to claims of greenwashing and legal action. Check carefully what you are aligning with.
Thank you, John. Divya, I have a last question for you, and then we're coming to the end of our time. But we're hearing so much about the devastating loss in biodiversity. When can we expect biodiversity liability to become material? In what ways can corporates face biodiversity-related litigation?
Thanks, Charlene. That's a very important question, I think, and I'd quickly address. I'm aware of the time as well. Human environmental damage has actually been rated as the 7th most severe risk on a global scale in the World Economic Forum's 2022 risks report. And it's only in due course of time that biodiversity litigation will be the next frontier in strategic litigation. There is the growing awareness of nature-related risks in financial markets will give rise to a very heightened standards of care. which is why we always emphasize on strong disclosures with complete due diligence done. Litigation risks can also arise from a failure to adequately report on biodiversity related risks or misrepresenting nature positive credentials. There's a very complex interplay of nature related dependencies and impacts, which over multiple time periods can result in earnings and cash flow vulnerability, ultimately transmitting itself into a financial risk. Could be a market risk, could be a credit risk, could be a liquidity risk, which is again why we stress on the importance of the TNFD framework, which will arise in future, is very important. Cases can evolve around private or public enforcement of environmental laws. Investors are already considering how to address biodiversity as part of their investment risk assessments. So this definitely means that there is a real risk of loss of access to financing for companies that cannot show a commitment to the global challenge of protecting and enhancing biodiversity. And I just want to highlight, because we talk about disclosures, how disclosures can be important. It just reminds me of a case in which it was a UK-based case, Lango v Vedanta, where the Supreme Court solely relied on Vedanta's public disclosures for the case and what they disclosed in the sustainability report, and they found the defendant guilty for what it was accused of. So that shows how important nature-related public disclosures can be as well.
Thank you, Divya, also to Nadine and John. And that brings us to the end of today's Cotton Masterclass on climate liability. I hope that you will join us for the following 3 sessions coming up. But before you leave, we have a quick request. We'd like to ask if you could please complete the post-session survey, which we're dropping the link into the chat now. And by completing the survey, you also get access to a session summary that will give you an overview of the points that we've covered today. So thank you very much, and we hope to see you again very soon. Goodbye.